Hello, guys, and welcome to episode 3. I am super excited to be here today with you guys, and especially as this is the first episode that has a guest speaker on today. And I'm super excited to bring my fellow founder and friend, Mika Mooney. She is a trademark lawyer, IP, all the legal things that you need for your business, and she'll give you all more information on exactly what she does. But today's episode is legal first, what founders need to know about trademarks and brand protection. And so with this podcast, the goal is to obviously give you guys these solo episodes where I talk about all the things about branding, really diving deep into it, but how these adjacent businesses and industries go hand in hand, so that way you can protect your business and do all the things that you need to do and have the tools for your business to do that, and bringing in experts to give you their knowledge, their tips and tricks on how to improve in business and how to just take your business to that next level. So let's give a warm welcome to Miss Mika Mooney. Mika, thank you so much for being here. I'm so excited for you to be my first guest.
Yeah, I'm so excited, Bianca. Thank you for having me.
Yeah.
And I'm obviously excited to chat about my favorite legal topic of trademarks
Yes.
protection.
Yes. Yeah, and I know you and I have talked about it quite a few. But just if you want to go ahead, give a little intro as to obviously who you are, what you do, the name of your business. We
Of
want to
course.
pimp you out so people can go follow you. So let everybody know who you are.
Yeah, I mean, I'm a one-woman show. So I am Mika Mooney, the founder of Mika Mooney Law. I started my firm in August of 2022 after 15 years as a litigator in New York. I'm still based out of New York, just outside Manhattan. And I am a business, trademark, and employment attorney for female founders. So what that looks like is lots of contract drafting, contract reviews, um, brand protection with trademarks and copyrights, and then employment counseling if you're growing a team and you're a New York-based business.
I love that. And these are all very important things that I think a lot of times, either if you don't necessarily have a business background or you don't know all the things that we need as a business, because it is a lot of stuff that we do need. These are very important things, especially as you grow in business and depending where you're wanting to take your business, if that does lead to an exit. So before we get started with all of the nitty gritty and all the golden nuggets that you have to share, I was going to say, I always like to ask my guests, but you're my first guest. But we're going to start it off on the podcast with that way. What was your why for wanting to start your business?
That's easy for me. I'm a mom to 3 girls. So they are kind of like my North Star for everything that I do. I want to lead by example. And I like to think that when they're older, that they will, think of mom and her career path and her entrepreneurial spirit and take away something from that. So as I mentioned, I was a litigator for 15 years, never planned on starting my own firm, but I knew I didn't want to litigate exclusively anymore. And I was one of those people who didn't like change. I think most people don't. So I kind of like stayed the
Mm-hmm.
course, stayed the path, stayed in the same job my entire career, even though I knew it wasn't the right fit for me. I don't recommend that to anyone. I made a promise to myself by a certain age that I'm not going to disclose here that I would make a change. It's okay. I'll disclose. It was actually 40. I was like, I
Okay.
am going to figure out my career before I turn 40. And I just kept thinking about my girls and that, there are a lot of things in your life that aren't in your control. Your career is not one of them.
Mm-hmm.
And so I kept my promise to myself. And here I am. And it's the best thing I've ever done. And I hope that it sets that example for my girls that I want it to.
I love that. And I love how, like, obviously there is that very personal and family aspect to it of like your why and why you want to do that. And I think that translates into obviously you wanting to be that role model for your daughters, but then also wanting to help females as well, like female founders, and just, you know, as women in general, we don't always have the control in our corporate careers and don't always get the advantages that we want to do. So I love that you're setting that role model example for your daughters, because I think it is that new kind of newer generation that is becoming more common for people to be, you know, entrepreneurs and everything like that. And I think that as, you know, as a mother, you can lead by that example, whether, you know, if your mother or anybody's mother, they were very hardworking. This is just kind of like that extra, that next level, if you will, and stuff. And I love that you can be that example for your daughters. And hopefully one day they might be working side by side with you in some
Who knows?
capacity. You guys might be taking over, but that would be really cool. You'd be your own like little version of like the Kardashians and like running your own like business empire. But I love that. And I love that you set that goal for yourself and starting that and be like, by this age, I'm going to make decisions and make that move and do something that I really feel proud about. So thank you for sharing your why. I always think it's very interesting to learn about a person as to why they start the things. And I think it tells about a person as well. So let's get into all of the exciting questions that I'm sure founders have been writing on their notebooks and asking, what do I need to know about trademarks and how to protect my brand? So we're going to go through these questions and it's just going to be that conversation. And again, this is really to give the founders just that knowledge that they need that they might not have ever heard of before for that trademark and legal protection. So for founders who are just starting out, all right. So, for founders who are just starting out, how would you explain what a trademark actually is and why it matters?
So in the most simplistic way, and this is why I think people can understand it, is trademarks protect brands identifiers. If you, whether you're a service-based business or a product-based business, there are certain things that form, you know, your business that people identify as part of your brand, right? So it's usually the business name, or it might be a logo, or it might be a slogan. So I'll always say Nike swoosh logo, just do it, right? Because people
Mm-hmm.
can get that. Um,
Right?
Trademarks protect those brand identifiers so that consumers aren't confused as to the origin of the goods or the services. So, you know, if there's two businesses with the same name selling the same product, that's not great, right, for either business. And
Yeah.
having a registered trademark gives you rights to enforce and to guard against, you know, that kind of confusion. So it's
Yeah.
down to brand protection.
Okay. And I guess like with that, like I'm sure there's founders out there that, you know, they might be smaller or just starting or not as long in the process that might be saying, well, I'm just starting out. I don't know where my business is going. Like, can I actually protect it if I'm that small? Like, why does it matter if I haven't, you know, quote unquote, made it yet
Yeah.
in their perspective?
So this is very, very common. Most business owners, I think, feel, well, I'll do it eventually when I reach a certain size or if I get there.
Mm-hmm.
And that's actually a big, probably misstep that many
Okay.
founders later learn that, you know, they should have done it before. You know, you don't have to be the Nikes of the world to,
Mm-hmm.
um, you know, file for trademark protection. And why it's important, no matter your size, you could be one solo person or, you know, three or five, whatever it is. Um, Number one, if you're coming up with a name and, you know, working on your branding and everything that goes along with it, the whole ethos, you want to make sure that you're not infringing on someone else's registered trademark, right? So someone
Right.
have the same, there could be another Mika Mooney law out there for trademark attorney services, and she has a registered trademark. And I want to be Mika Mooney law, and so you don't want to infringe on someone else's registered trademark. That's number one. Two, you're going to put in all of this time, energy, effort, and investment into building a brand. It doesn't matter whether it's service or product. And you want to protect it, right? You want to clear it, and you want to make sure that you kind of lock it down so that 2 years from now, when you're out, doing your thing, and you take off, that someone else doesn't come along and apply for trademark registration for the same exact name, doing the same exact thing.
Right.
So it's kind of it's twofold, right?
Mm-hmm.
And you save. What founders often don't realize is being reactive to a situation that later arises is worse and more costly than if they have been proactive from the get-go.
Mm-hmm. Yeah, and I think that's one of the things too, that it's like you said, they might not think that, oh, I haven't made it yet. I'm not a Nike of the world yet. I can just do it later. But it does then in the end or in the future lead to those, financial potential, consequences that you might be doing great. Someone already else has it. So with that being said, it tends to be, I guess, kind of like that overlooked critical piece of a business. And ultimately, what would be like in just a few words, like why, if you were to talk to like a founder and tell them like, what is the critical piece of brand protection when you're building a business? Like, why is that something that is so key when they're kind of just starting? Because I think that's something that even you and I have talked about off camera, is that it's always that delayed reaction to do it, or like a afterthought per se. So, if they were to ask you like, why is brand protection such a critical piece of building my business?
I
What
mean,
would you tell them?
at the end of the day, it's an asset of your business. So if you're not going to secure what you're building and the asset of your
Hmm.
business, from a financial perspective, you'll lose money. All right.
Right.
And then set aside the finance component of it. A lot of founders, the brand, the name, whatever it is, usually means a lot to them. And
Hmm.
it becomes part of their identity somewhere along the line, right? So it becomes personal and potentially heartbreaking if they have to then later part with it. So
Yeah, and I think that's crucial too, because, obviously from the branding side, when I work with founders, there is, like you said, there is that sentimental, emotional attachment to the name, and that it's like, I'm stuck on this. This is what it's going to be. But reminding them, like you said, from a legal standpoint and just from like an asset of your company, that if that's not available and you move forward with it, then it just leads to so many complications, if you will. And kind of just talking on that, like, what and have you ever had those situations where people are like, no, Mika, we're going to do this, we're going to go forward with it, or I'm not going to trademark it and I'm going to move forward with the name, even if it's not available? And I guess that kind of goes into like my next question of like, what are those common mistakes, or what happens to early stage founders when that happens, if they aren't open to that pivot and they just decide, I'm sticking with this name, I love it,
right.
I'm going to be a hard head and continue?
Yeah. So, at the end of the day, each trademark is a unique analysis, right? Any trademark attorney working with a client is going to go undertake a thorough search and um, provide a unique analysis and opinion with respect to that one mark, right? However, it's the business owner's decision on what to do with that
Mhm.
information, right? So
Right.
some might decide to give it a fighting shot, or they might want to roll the dice. Others might just want to completely choose something, a different name altogether. I think it's just a matter of risk tolerance, right? Some people
Yeah.
are more risk adverse, other people are risk takers. So I think it's all relative to the particular mark, the circumstances surrounding it, and what's reported by counsel for that, and then the business's appetite for risk, and it's ultimately the business decision to be made by the founder.
Yeah. And I think just going off of that, if the founder does decide, I'm going to take the more risky, decision, or, it might be already be taken, I'm going to do it anyways. What are some of those negative repercussions for a founder if they decide to go down that road and ignore what legal counsel has advised to them?
So, look, it's nuanced, right? Because it's not just identical names, it's same or similar, right? The USPTO is looking
Mhm.
not only identical marks, but are there any similar marks for the same or similar goods or services? So there could be two identical, names, Dove chocolate, Dove body wash, two completely different products. Not an issue, right?
That's fine.
But when if it's similar, then it's a potential issue. So what that might look like down the road is the founder might receive what's called a 2D likelihood of confusion office action from the USPTO. And that is the examining attorney at the USPTO telling the founder, hey, we think your mark is confusingly similar to these two other marks, and the goods and services are either identical or they're close enough that that consumers might be confused as to the origin of the goods or services between the two marks. So then the founder has to decide, okay, um, do I have any arguments to overcome that office action, right? And that's something an attorney will walk them through, and they have to decide, okay, now do I want to pay counsel to put in a response to that office action? And is it
Right.
right? And there's no guarantee that I'll be successful.
Mhm.
And, then it's also, besides the legal fees associated with that, um, for a product-based brand, it's maybe also coinciding with a launch, right? Or
Mhm.
product going into production. Do we have, you know, packaging with labels, and do we have, you know, items being made with the name of the brand, but it's not going through yet for trademark purposes. So are you going to delay a launch? Are you going to move forward with a launch, and hope that the trademark issues work out for the best? Or are you going to rebrand? So there's, a lot of considerations that have to be taken into account.
Oh, yeah, for sure. And I think especially with product-based businesses, there's a lot more time and investment that goes into it that you want to make sure that you have that name cleared to use and trademark because as you said, if you have a launch that's coming and you've put that name on all of the packaging, it's on the website, it's on the promotional things, that's a lot of stuff that you've already paid for that you might not be certain that it is actually protected. And then you might have to go back and redo it all again. And then you're going to have all this inventory on hand that one, you don't know what's the rate that it's going to sell at. So you're sitting on inventory and cost of goods right there. But if it doesn't get sold, then you have to reprint all of the labeling. And then just depending on how you did label everything, is it just the actual boxes, or does the actual product have the name on it as well? So it starts to become a very pricey situation if you haven't done it. I always tell my clients that are product-based businesses, especially, that before you go into that, because of my background in product development and production, I know the cost that goes into producing things, that you have to make sure that you are making that research done, whether or not your name is protected or not, because of all of that. And so I hope you guys that are listening and watching, that you can start to see how these numbers are starting to add up if you don't do it from the beginning, especially because I do think that is something that founders, in their mind, they're like, oh, it's too expensive, I'll do it later once I have the money. But as you heard Mika just said, that, it's not only just the redoing of your brand, all the packaging and all that stuff, but it's the attorney fees to litigate and do all of that stuff if you're really set on that name. So I can guarantee you that the cost of what it would be to trademark is a very small fraction of what the bigger price can be if you have those issues at the end of the day.
Yeah.
Um, yeah, and so that's not a fun thing, especially as a starting founder. So what else would you say, aside from kind of like the delaying of, doing the trademarking, what are some other like most common trademark mistakes you see early stage founders do?
I think there's a big kind of misguided misinformation. Like a lot of times founders think LLC, it's the name of my brand. I have the domain. And so that means it's available, and so I'm good. So I think that one, not looking into it and could be one of the first things they're doing. And then two, having this misguided idea that these other things provide them with that trademark level protection. Oh, I can't hear you, Bianca.
Can you hear me now? Okay, perfect. Technology just doesn't want to work today. And I think those are good things to, again, for early stage founders or just founders in general to think about, because it's not stuff that necessarily just comes to mind and we're like, oh, this is the stuff that I need to think about from a trademark perspective and how to protect my brand at the end of the day. So I appreciate you sharing that, because again, it just starts to get the wheels turning on stuff that founders we might not have thought about from the beginning and everything. So can you share a story, obviously without mentioning any names, but of a founder who skipped trademarking and later paid the price?
Yeah, I mean, I can't obviously as an attorney maintain
Obviously, yes.
confidentiality and everything. I can't share any specifics
Just an
on, but
overall
scenario,
example.
um,
Yeah.
you know, the a common scenario often is a founder has it in their mind, okay, eventually I'm going to get around to doing this. And then all the other things that go along with starting a business is more exciting, right? The work that you do, Bianca, like everyone's so excited about branding and the website and the messaging and all the creative components.
Hmm.
I think founders often are focused on that because that's
Yeah.
the fun part, right?
That's
And
the fun part of it. Yeah.
the other stuff is not as exciting. Even though maybe they're alerted to it, it's in their mind. Okay, my my amazing branding web designer person Bianca told me that I need to think about this, and like I hear her, but I'm just gonna wait. I Googled or I chat GPT'd and I didn't see anything, and like so I'm just gonna wait.
Let's not do that.
Now, that's a common scenario. And then later on, let's call it a year or two down the road, said founder finds out, oh my God, there's, a competitor who's doing the same thing that I'm doing. And
Mm-hmm.
in fact, someone reached out and asked if that was me, because
Right.
we have the same or similar name. And now the founder's like, crap, what do I do? And
Yeah.
the stress that comes along with that, that is not an uncommon scenario. And then has to deal with that scenario, which always costs more than had they
Invested in the beginning.
from the beginning. Always. There's no two ways about it. So,
Right.
um, and that is a very common situation um,
Gotcha.
for a founder to find themselves in.
Right. I can only imagine that. And I'm sure, obviously not all founders are lawyers. We didn't get, we didn't pass the bar. We didn't go to school for that. So I'm curious if you could just obviously like kind of explain the differences. And, I always tell people there are no dumb questions. These are things that it might not be up your alley. And you might not know these things, especially with legal terms and structures. But what's the difference between having a trademark and simply registering your business name or domain? Because I'm sure, or I'm curious actually, like if people have come to you, they're like, I've registered the name, and then they might think that that's in a way of them claiming the name. But I'd love for you to just break that down, because again, I think these are very key things that founders should know what those differences are in just layman terms for their business.
So I think, like most founders, at least when they're, business planning, they're like, okay, I have to form an entity, whether it's a corporation, whether it's an LLC, I have to form my entity. Generally, you have to name that entity. Whatever state you're forming it in the United States, you have to come up with name. In New York, no two entities can have the same name. So
Mm-hmm.
a founder easily thinks, I registered my name, my Mika Mooney Law PLLC. It went through, so I'm good. What they don't realize is that um, registering for an entity has nothing to do with federally registering a trademark. They're two completely separate processes, two completely separate things, right? Like one you're forming with the state
Mm-hmm.
is a federal, the entire United States protection if should you receive a trademark registration. So the two have nothing to do with one another. A name
Mm-hmm.
available for entity formation purposes, but then it's not available or it's risky for trademark purposes. So
Mm-hmm.
two ideally should be done at the same time.
Got it. Okay. And would you do one, like, would you do the trademarking of a name first and then registering it? Or if you register and then do a DBA with the trademark name, is that one versus the other? Because I feel like people are like, let me just register, let me get my LLC so I can make it
Yeah.
official.
And that's fine, right? Like
Mm-hmm.
you can form an entity and name it whatever you want to name it, but what you are actually going to be operating as might be separate, and you clear that for trademark purposes, and then
Mm-hmm.
file your DBA. If you want them to be the same names, though, do it at the same time. Uh,
Okay.
but it's a huge mistake to think that um, having a registered
It
entity
registered is
is
protected.
the same as a federal trademark registration.
Right.
Two,
And that's very crucial. Like you said, like one is state and one is federal, and you want that federal protection to protect your entity and everything. And with that being said, obviously we've talked about, either you holding it off and doing it later or what makes sense. When is, everybody likes to ask the question, when is the right time for a founder to start the trademarking process?
from
Ideally.
from the very beginning,
Okay.
before they have launched, when they first are meeting with you, Bianca, and you're helping them with their branding. Maybe you're helping them come up with their name. Like they have their idea for their product or their service, and they're doing all of that creative work. That should simultaneously also be done with clearing for trademark purposes.
Mm-hmm.
So
100%.
like it should be done at in those very early stages. That's the best time.
Got it.
You have no idea
Okay.
how happy I am when someone comes to me and they're like, I'm just in the early stages. And I'm like,
You're the golden child. I appreciate this.
that's what I want to see.
I
I
love it.
trademark lawyer out there would say the same.
All right, guys. So you heard it. Like, if you are thinking about starting a business, don't wait until 2, 3 years or a year that you've done everything to do it. The ideal situation, so you're most protected, is right at the beginning. So, with that being said, what would you say is the first thing that a founder should consider to protect? Is it the name, the logo, the product names? Because I know, again, we've talked about this offline, and I think, again, this is so interesting. I love to geek out on it, but there are some things that have more oomph and power of protecting versus the other as an early stage founder. So, what would be those first things you would tell them to consider protecting?
Yeah. So I think this varies on
Okay.
factors. Number one,
Okay.
probably being budget, right? What's the legal budget? Is in the budget to trademark everything under the sun or in connection with the brand, apply for it, clear it, those legal fees, right? Smaller founders or startup founders, they're working with trying to, a certain amount of capital that they're trying to spread across many different things, right? So, um, you know, in that case, then they might have to start prioritizing what's number one. I'll always say the the name, right? And stand
Right.
for,
Mm-hmm.
no matter black or white, color, capital, lowercase, whatever kind of font, that would be um, the priority. And then you
Okay.
start thinking about logos or taglines. Sometimes people do is they make mistakes with logos. They apply for it, but
They
then
change it.
they change it. They change it in some
Yep.
way, and now their trademark registration is
It's no longer viable.
like they have to use it in the way that they applied for it. I do think that for product-based brands,
Mm-hmm.
a lot of times the logo is very important because the product will carry the logo and
Right.
packaging, and there'll be a lot of emphasis on the logo. Uh,
Okay.
so if that's the case for that particular brand, then maybe it's both. The priority is actually both logo and the name at the same time. But they
Okay.
always think, am I with this logo for like kind of
Forever.
like not forever, but like
Mm-hmm.
I'm not going to change it next year or 2 years from now.
Right.
I'm not going to
Right.
launch with a different logo than what I applied for.
Mm-hmm. Okay. So I guess like basically like a change in the logo. If you were to trademark that logo, then you have to reapply for a whole new trademark essentially for that logo. Like if Coke, like
Material
the
change, like depending on like what it looks like, you'd have to. It's hard in the abstract to say, but like
mm-hmm.
two side by side, and there was some sort of material change, um, you would have to reapply. So I'm
And
conservative in saying if you're going to change this logo in any way,
yeah, even though it's just like slight hair of a change, it still is you got to start all over again. Interesting. Okay, so then Coke has maybe done that a few times because their logo, it still pretty much is the same over the years, but it's slightly varied.
now there might be like, you have to be using the mark in the way that you've applied for it. So
Okay. And what does that mean to us non-lawyer people?
you can't, I mean, if I applied for Mika Mooney Law, but I'm
Mhm.
using Mika Mooney Law ESQ at the end, that's
Okay.
mark. So if there's an
Right.
design element to the mark, it's a different mark. So each mark requires
Okay.
a separate application.
Got it.
I haven't
Okay.
coax trademark registration, but they very well might have registrations for all of them.
Right. And I would think, I guess, like, those bigger businesses, they probably do protect all of those entities because they are such massive companies
Mhm.
at the end of the day.
Yeah, trademark portfolios.
I can imagine.
To say that a small business owner can also have their own trademark
Hmm.
portfolio. And I think a lot of times founders are like, oh, well, I'm just, we're a small business, so it doesn't matter. But it really does equally for small and big businesses, the same.
Yeah, for sure. And so once they've, come to the decision, okay, let's start the trademarking process. What does that process of filing a trademark look like, and how long does it usually take? I know things have changed a bit and have
Yeah.
gotten extended. So
It's
what
a
is that
lot.
kind of?
It's a long process. I
It's
think,
a marathon, not a sprint.
and this is the thing, people often think, oh, well, I formed an LLC in the matter of a day. Like I can do the same.
I'll be trademarked by tomorrow.
It just, that is not how it goes. The USPTO has gotten better, you know, but it's still probably about 6 months at best when currently, from when you might hear back from the USPTO on your.
And does that would be like kind of like the standard average regardless of what state you're in? Or would someone think like, I'm in New York, it's going to be quicker across the board? It's like that average time frame. Okay.
Yeah. So at best, maybe 8 months is more average. So, once the application's filed, it's going to be a decent number of months till you'll hear back. So that
Okay.
goes towards why it's important to do it like kind of one of the first things you're doing, because it's going to take some time. And within that time, you're not going to, most founders aren't waiting. They're not
Mm-hmm.
to work on their business until they hear back from that. So they might be kind of like, okay, if I have to change, how quickly can I change? Right. Like if you're doing,
Right.
say, how quickly can you change like the name or the logo or something like that? Our messaging will be the same, but if we have to change the name, can we readily do that? Or if it's a product brand, like, um, okay, my chances look good, but maybe I'm going to order minimum quantities. I'm not going to stockpile a large quantity in case, I don't get the news that I want to receive.
Gotcha.
But, all that also takes time. So it's better if like the trademark application went in as one of the first things.
Mm-hmm.
When you get to that point, you'll know. You'll know where
Okay.
you're at with the USPTO. So like
Gotcha.
before you have to commit to ordering,
All those other stuff. Yeah.
and you'll hear back.
Yeah. And I guess like when you're working on that process, do you tend to be like, kind of like give a red light, green light, yellow light of like, this is the viability of the name
Yeah,
being okay or not? So that way, as you mentioned, all these other things that are simultaneously happening for them to kind of feel more comfortable, I guess, like getting those other things done and not be like, oh, well, we're not going to be able to do this. Let's start all over again.
yeah. Yeah, so sort of I do high risk, moderate risk, low risk, sometimes
Okay.
low, um, to let the business owner know, okay, you're high risk, probably going to receive a 2D likelihood of confusion of office action because of these two marks. And here's why I think you will. Or something is more moderate risk. And here are these marks that might be cited, but we have arguments and ways to distinguish. And like your services are completely different from their services. And if we were to get an office action, we have arguments to overcome it. Sometimes
Gotcha.
the USPTO examining attorneys, they get it wrong, and they issue some crazy, 2D office action, and trademark attorneys like, that makes no sense. And here's why. The lawyer
Okay.
to overcome it. Um, yeah, so it's like the business owner should have like some idea of
Of the risk
what that looks
so they can make those decisions accordingly and stuff.
like, and that way
Okay.
they're not surprised.
Right. And that way, at least they have a judgment of like, okay, I can do this, I can't do this, and making those educated decisions based on that information. So, with that, when someone comes to you, what should they have already like ready before even speaking to you as a trademark attorney if they're wanting to get that done?
Honestly, I love chatting trademarks, so I'll chat with anyone. They don't have to have anything done. But
Okay.
I'll look
That's good to
at
know.
I'm providing some trademark education. I love providing legal education. So they, at some point, if they're going to, let's say they work with me, I'm going to need them to complete a trademark intake form. And within that form, I need to know, what do they want to apply for trademark protection for? Is it this name? Do they have a name? Do they have some slogan that encapsulates what their whole business is about? Um, and they need to also know what their services or products are, because
Yeah.
why for trademark registration in connection with goods or services that fall into different international classes, basically categories. So if you're like,
Right.
I might do this, I might do that, I don't know, and a little wishy-washy about it, and then 6 months later you're not doing any of it and you're doing something else, but you didn't apply in that class, well, at that point you'd have to submit a whole new application.
And I would assume you don't get protection, you wouldn't be protected if you were like, if you got that trademark protected under different types of services and then you started doing
Well,
something
no,
completely different of that.
it's not even about whether you'd be protected or not. It's that you're not actually providing those services or selling the goods that you applied for.
Mhm.
So it's not, how are you going to, if you're on a 1B intent to use basis, you wouldn't be able to tell the USPTO, yeah, I'm using this mark, right? And here's the evidence. You
Mhm.
have to submit evidence showing that you're using it. If you're on a 1A basis, you're also then open to potential cancellation by somebody else who wants a mark. Hey, they're not actually
They're
providing
not actually using it or providing
in that connection with that. So um, it's important, like, to have an idea of like what it is you're actually going to be doing or something.
right. And that way it just makes it easier for you when helping them. And then even just from like the brand part of it, it helps that part of the process make it more seamless to determine those things. So kind of segueing with that, how would you say like a founder can align their brand strategy with legal strategy from day one?
I mean, I think ideally, if they are considering their brand strategy with a legal lens and aligning
Hmm.
to, um, that they can kind of simultaneously execute them together. And if they have a brand, someone like yourself, like a brand partner, and then they have legal counsel, um, it can all be more fluid and seamless if the two work together. And
Okay.
and I think it helps the founder button up the legal side of branding, and maybe also help in terms of like honing in on exactly what it is that they're going to be doing, what services
Hmm.
and what are they going to be selling, what their actual intent is. So
Right.
I think if they have those partners in alignment together, it could move a lot.
That would be like the ideal situation and just make it, I guess, more of a streamlined process versus like super choppy, or there's no like understanding of what the end goal is from the brand perspective of things.
Yeah.
Perfect. I love it. And that was going to be my next question. I'm like, but Mika already just answered it. She knew I was going to get there. But, and that's something that you and I have talked about, is that like how branding and trademarking are so crucial for a business to do simultaneously. So that way, long term, you don't have to invest so much time and energy into legal fees or redoing your brand, because it does add up. If you guys have been, catching along this whole conversation, is that it can become very costly very quickly if you don't do these things from the beginning. And obviously the goal from a business perspective is that you don't want to have to be rebranding all the time. That's not the objective of it. So if you can determine your name from the beginning, protect that and protect your brand, that just leads to the better trajectory for your business
And
at the end
all
of the
the
day.
growth that you have surrounding it, like not to
100%.
change it later. And, I think it's just, to me, it's just this no-brainer.
Yeah. And I'm curious, like, from your perspective as a trademark lawyer, because I will hear people say, like, oh, like, I don't need to do branding. Like, I can just do it later. And if I have to redo it, I'll just redo it. It's fine. It can be done. And I guess from like a trademark perspective, like if someone were to tell you that, like, oh, I can just re-trademark, it's okay. Don't worry about it. It doesn't matter. Like, what kind of red flags does that bring to you as a trademark attorney? That, oh, I
Yeah,
can just redo it. Like, I can just get a divorce. It'll be fine.
I think it's just a little naive. And if you're willing to do that, and maybe have to, if you're willing to accept that as a consequence or a risk or whatever the case might be, um, then, it might be a learning experience for the founder
Sure.
down the
Yes.
road.
Okay.
Um,
Definitely a learning experience for sure. And as we are getting to the end with all of these golden nuggets that you have shared, um, what would be one piece of advice you'd give to every founder who's listening who hasn't trademarked anything yet? Obviously, we've talked a lot about good takeaways of why you should be doing it, but what would be that one piece of advice that, for the founders who are listening?
I think at least educate yourself on intellectual property laws and the value of intellectual property. That could be, go to the USPTO website. The USPTO puts out a lot of educational resources on trademarks and YouTube videos and all these things, right? I think at least spend a little bit of time um, educating yourself on it. So that way, whatever decision you make, at least you've spent some time researching and learning about
Definitely.
this and the importance of them.
Perfect. And I also know, because I always love to give, you know, things to the founders and the people who are listening, of just more information tools for them to use. And I know I've seen on your Instagrams and even on your LinkedIn's that you do have little like freebies or with more information. And where can people find that? And, tell them where they can find you, because you do give a lot of great information. And I want y'all to make sure to go follow Mika for all of your trademark education, because she has a lot of great tips,
Like I
guys.
say, I love spreading legal education. Um, I'm Mika Mooney Law everywhere. So you could go to my website, mikamooneylaw.com. I have a really fun trademark readiness quiz. So if you want to find out if your business is trademark ready, you could go take this quiz. I promise you, it's painless. I also have a trademark starter kit. So if you want like kind of a combination of trademark information, there I have that starter kit. Both are on my website. They're also in my like Instagram links. So at Mika Mooney Law. I'm also on LinkedIn at Mika Mooney. I put out a newsletter every other week on some fun trademark information and news. And, these are all things for trademark legal education purposes, just like this
I
conversation,
love
right?
it. Yes,
I'm attorney
yes. And
relationship,
she is
but
not the typical lawyer. She's a cool lawyer. You can see it from her branding and, you know, again, from a brand consistency perspective, I love that. Makes it easy to be like, I'm Mika Mooney Law everywhere, consistency with it. And I'll actually share the links to those two things that you mentioned, like the quiz and the pack. So that way we will put that in the show notes so people can easily access it. But Mika, thank you so much for joining me today. I appreciate it. Thank you for sharing all the golden nuggets with us here today, with the listeners and the viewers. I think, again, as founders, there are those things that might not be the so quote unquote glamorous, but these are like the key and really important things that protect your business and allow you to take it to the level that you want to. So these are the things that we have to make sure that we're implementing into our foundation as a founder. So thank you so much for sharing those golden nuggets with us. And guys, make sure to go give her a follow. All of her links will be in the show notes. And make sure you go give her a follow. Mika, again, thank you so much for your time and for joining us today. I appreciate it.
thanks, guys. Bye.